Of all the legal institutions that have claimed a Saxon origin, none compares for importance with that of trial by jury. This has been called the bulwark of English liberty, and it has been assigned to King Alfred as the general founder of great institutions. But this is only a popular opinion. In the vast literature which the subject has called forth, the most various accounts have been proposed. It is an English institution, but whence did the English get it? From which of the various sources that have contributed to the composite life of the English nation? Was it Anglo-Saxon, or was it Anglo-Norman, or was it Celtic? Was it a process common to all the Germanic family? If it was Norman, from which source? From their Scandinavian ancestors or from their Frankish neighbours? All these origins have been maintained, and others besides these. According to some writers, it is a relic of Roman law, some trace it to the canon law, and champions have not been wanting to vindicate it as originally a Slavonic institution which the Angles brought from their old mother country. The Anglo-Saxon laws have been diligently scanned to see if the practice or the germ of it could be discovered there. In the statutes of Athelred there is an ordinance that runs thus.
And ganit thael destanc si thegnas. Let
the 12 senior thanes go out, and the reeve with them, and swear on the halidom that is put in their hand, that they will not calumniate any sackless man, nor conceal any guilty one. This looks like the grand jury examining the bills of indictment before trial, and determining prima facie whether they are true bills which ought to be tried in court. But the progress of modern inquiry has led to the conclusion, that though there may be rudiments of the principle in Anglo-Saxon and in all Germanic customs, still it was among the Franks in the Carling era that a definite beginning can first be recognized. The Frankish capitularies had a process called inquisitio, which was adopted into Norman law, and was there called enquête. This, having passed with the Normans into England, was finally shaped and embodied in the common law among the legal reforms of Henry II. Under the Saxon laws, the true men who were sworn to do justice had a very different part to act from that which falls to the lot of our juries. The duty of the latter is to deliver a verdict on matter of fact as proved by evidence given in court. The judge charges them to put aside what they may have heard out of court, and let it have no influence on their verdict, but to let that verdict be strictly based upon the evidence of witnesses before the court. In Athelred's time it was different. The sworn men were not to judge testimony truly, but to bear witness truly. They were to bring into court their own knowledge of the case, and of any circumstances that threw light upon it, including the general opinion and persuasion of the neighborhood. There was no attempt to collect evidence piecemeal, and to rise above the level of local rumor, by a patient judicial investigation. The notion of weighing evidence had not taken its place among the institutions of public life. Witnesses came into court, not to speak, one by one, to a matter of fact, but to pronounce in a body what they all believed and held. They came to testify and uphold the popular opinion. Such testimony is like nothing known to us now, except when witnesses are called to speak to general character. These witnesses gave their evidence on oath, but it would naturally happen sometimes that such sworn testimony was to be had on both sides of the question. When this was the case, there was but one resource left, and that was the ordeal. But, withal, it was in such a rude age that the foundations of English law were laid, and those customs took a definite form which are the groundwork of our jurisprudence, and in which consists the distinction between our English law, and the law of the other nations of Western Europe, who have all formed their legal system upon the civil law of Rome.